So welcome everyone to this evening session. I was reflecting where we started this morning with the Lieutenant Governor, who gave us a bit of a warning about language. You'll recall when he used the phrase Douglas Treaty, he talked about how that symbolized some of the marginalization of Indigenous peoples in Canada's history. And it caused me to reflect, and I spoke to a number of the chiefs gathered about this issue of language, because it dawned on me, certainly in all of my years interacting with the Crown, that I had only ever heard Crown representatives refer to these treaties when meeting with First Nations as your treaties. Never, and I asked chiefs, and they also affirmed, never have they heard a Crown representative say our treaty. And it sort of reinforced in my mind how the story, and it's so ironic, but the story of these treaties, from the moment they come into the public imagination, the legal imagination of this country, which is the topic of our discussion tonight, that they have been framed and talked about as a source of conflict and division, rather than what they, and what we've heard about from all of the speakers today, as a coming together, as the foundation of a relationship, as a coming together from many directions of different peoples trying to articulate and express their way forward together. Now, I don't know what your relationships are like, but I know that in my life, if I perceive of a relationship through the lens of conflict, I create conflict. And if I perceive that relationship through the lens of what we are together and trying to understand and build on that, then indeed we build something together. And it's interesting, we heard this morning about the origins of the legal evolution and legal interpretation and legal understanding of these treaties, which begins here in this territory, begins with nations here in the forefront, begins with this gentleman, who I'll introduce in a moment, helping to lead the charge in what's been called the first shot in the courts, in the unfoldment and history of Aboriginal peoples in Canada. But if you look back at that time, and I heard stories today from family members of Clifford White and David Bobb of how outside the courtroom things were thrown at them by the public, how they were insulted and ostracized in the community for years, just for the mere fact of standing up and saying there is a treaty. The headlines in the newspapers in those days: 2 Indians challenge powers of white man. The case of the Indian versus the white man's laws. Treaty turns out to be only scrap of paper. That's before Mr. Berger got involved. Old treaty worthless to Indians, right? The whole sense of conflict, division, this mere fact of speaking and asserting the treaty itself as what divides us rather than what connects us. But if you fast forward over the years, if you talk to the Sayout people and the Sartlip people and the people on the peninsula and the treaty nations up and down the island, if you hear, for example, the stories they tell about the Claxton case, the Sayout people, and how they sacrificed and, even in their word, bankrupted their community to stand up and honor the relationship in the treaty. And the Sartlip people, the same in the Morris case, how they sacrificed tremendously to uphold that treaty. Yet still, the way we frame it and understand it is through this conflict orientation. Headlines from today: Natives' claim draws testy retort. It's about asserting the treaty. References to not giving in to First Nations threats of the Douglas Treaty. These are quotes. Assertions by the treaty being reported as, quote, childlike and arbitrarily abusing power. That was this year. It's interesting. We describe people, these nations, who are willing to sacrifice everything to uphold that relationship, to suffer great indignity and great prejudice to uphold it. Yet here we have crown entities who won't say our, will only say your. Here we have Mr. Berger is going to tell us about how when he stood up in court with Clifford White and David Bobb, the argument was there was no treaty. They had to find the treaty. Well, this year, when you write the federal government and say, let us work on implementing the treaty, they don't say it doesn't exist. Minister Duncan writes, Canada recognizes Douglas treaties as treaties protected under Section 35 of the Canadian Constitution. Sounds like a good start. Next word, however. Here we go. And what's the however? Canada is of the view that uncertainty exists regarding the scope, application, and meaning of Douglas Treaty rights. What do we do in conditions of uncertainty? They go on to say, please negotiate a comprehensive modern treaty under the British Columbia treaty process. So it's not that it doesn't exist, however, can we just ignore its existence? So how did we get, there's a relation, I don't know of any relationship that works where one party is ready to sacrifice everything and the other wishes to ignore the existence of the relationship itself. But that is the situation in which we remain. Tonight, we want to explore, in some respects, how we got to this place that we're still in. And to understand it, it's always fundamentally important to look at the origins. The origins of when the courts first began to engage these issues. And there is no one who could lead us through this discussion other than Thomas Berger. I'm sure he is well known to all of you for his many, many outstanding achievements as a justice, as a lawyer, of the commissions and inquiries he's led all over this country. But what he stands for is really, throughout his life's work, being the conscience of justice. The conscience of justice in public life. And in two seminal moments, and there's many, but we can highlight two in which he did that. One was in this case, White and Bobb, standing up early in his legal career and putting in motion a transformation in the law. Other ones that we know of is how he stood up in the early 1980s about the necessity for the Constitution to enshrine protections in Section 35. In all of these public acts, being the conscience of justice and equality in this nation. So I'd like you all to please join me in welcoming Thomas Berger to give our keynote tonight.
Well, thank you, Roshan and friends, and it's a delight to be here again and to be so warmly received. At my age, you get used to having people saying nice things about you, if only because you've been around a long time. But I always think of the day I became a judge. I was appointed a judge when I was still in my 30s. In those days, that was kind of youthful for that sort of position. And my father, who had been in the RCMP on the prairies in the old days, said, "You know, Tom, remember, now that you're a judge, there's a lot of wisdom out there on the farm and on the street and in the bush." And he told me a story about a new judge appointed on the prairies in the old days. And the judge's first case was a case of a young man who'd been charged with stealing a horse. And the evidence against him was pretty strong. It looked as if he really had stolen the horse. The jury was a jury of prairie farmers who knew the young man pretty well. They were reluctant to convict. At any event, they heard all the evidence, and the judge summed up the case for them and sent them out and said, "Now, I want you, Mr. Foreman, and members of the jury, to consider your verdict." They came back, and the foreman said, "Well, Your Honor, we find the defendant not guilty, but we think he should give the horse back." And the judge, preening himself on his knowledge of the law, newly acquired, said, "Well," in a patronizing way, "Well, Mr. Foreman, members of the jury, that's what in law we call an inconsistent verdict. And I'll have to send you back to the jury room to reconsider your verdict." So away they went. Returned a few minutes later, and the judge said, "Well, have you reached a verdict?" "Yes, Your Honor, we have. We find the defendant not guilty, and we've decided that he can keep the horse." So I should tell you that in the early 60s, I opened my own law office and in Vancouver. And I should tell you that my mother, who was widowed early in life, was my secretary and receptionist. This was a pretty much a shoestring operation in those days. And I still remember my first client who came in. He had been charged with impaired driving. I had done some criminal defense work before that. And the trouble with my office was there was a desk, but there was only one chair. And I thought, how am I going to handle this? I can't very well sit in the chair and have him stand there. Anyway, I figured it out that I would put the chair on that side of the desk, and I would sit casually on the corner of the desk. And it shows a capacity, I think, at an early age for improvisation. And well, I had worked with a lawyer named Tom Hurley, and I want to bring his wife into the story soon, but he was the dean of criminal lawyers in Vancouver, and he was in his late 70s, and he wore an old three-piece suit, and the tobacco ash was all over his vest, and he was a man who liked to take a drink, but he was a damn good lawyer and had argued some of the most important criminal cases in the province's history. But his wife, Maisie Hurley, worked with him, and she was a defender of the cause of the Aboriginal people in this province, and she was a woman of no uncertain convictions. She was the founder of the Native Voice. She painted portraits of many of the chiefs of the time. There's a whole section in the North Vancouver museum devoted to Mrs. Hurley. But she objected to her husband taking a drink, and I would go down to see Mr. Hurley to get some advice about some of the cases I was doing, criminal cases. And he would say, well, let's go over to the Olympic Hotel to talk about this. That was a beer parlor. And, but he kind of went, put his finger to his lips. And Maisie Hurley had an office across the way, and if we were very quiet, we could get out of Tom's office and get out to the main door into the hallway undetected. But one day I was there and she came out and she said, "Where are you going, Tom Hurley?" And he said, "Just going out for a conference with Mr. Berger, my love." She said, "No, you're not. You're going to the beer parlor. I know that." And she had a cane. She was tall and had horn-rimmed glasses and black hair and wore a black quilted dress. She was a formidable figure, and she came after us with the cane, and he said, "My love, how can you say this about me? You're going to the beer parlor, you bastard." And we got out the door with her cane ricocheting off the frosted glass on the window of the door. We got to the elevator, and the doors shut, and we were headed down, and Tom wiped his brow and turned to me and said, "Didn't I tell her?" Anyway, I should tell you that Roshan said I'd explain how all of this started, so it's all part of the story. Tom Hurley died not long after that, and Maisie came into my little office and burst past my mother. I knew that Tom had died, and she stood over my desk and took her cane and rapped it on the edge of the desk and said, "Now, Tommy, you will have to defend the Indians." Well, it's one of those big moments in your life. You may not be altogether aware of it, but that accounts for the fact that I'm here today. It's kind of like getting married. After it's all happened, you're not quite sure how that all came about. But one of the first cases she brought to me was the case of Clifford White and David Bobb, two young men of the Nanaimo First Nation who were charged with hunting deer out of season. And that offense occurred on July 7th, 1963. So that's 49 years ago. And they had been convicted in what we used to call the magistrate's court. We now call it the provincial court, and sentenced to pay a fine of $100 each, and in lieu of payment of the fine, 40 days in jail. And one of them was still in jail, hadn't been able to raise $100, and was serving time in prison. And Maisie brought in a wealthy friend of hers. She conscripted, thanks very much. She conscripted wealthy people to help her in this cause, who came in with $100, and we were able to get both of our clients out of jail. Well, they were out hunting for food for their children near Mount Benson, on the slopes of Mount Benson. And between them, they had 13 children. And Luella, Clifford White's granddaughter, was telling me today that Clifford told her more than once that they were hunting as well for other people who needed food. Well, let me tell you that this case sounds quite straightforward, but I went to the reserve here in Nanaimo, and I met with the council, and many of the elders were there. And you'll appreciate, to this point, this is just an ordinary case of an offense against the Game Act, hunting deer out of season, during the closed season. Not supposed to do it. That's what the Game Act says. And so I sat down with the council and the elders, and many of the elders talked about a treaty. And I was mystified. I said, "Well, what treaty?" "Well, we made a treaty about 100 years ago with Governor Douglas." And I said, "Oh, well, anybody got it?" And nobody said, "No, but there's a treaty." And that's what our forebears have told us. And then they talked about Aboriginal title. They said, we entered into that treaty, and they had to make a treaty with us because we had Aboriginal title to this land and to this province. Now, I had been to law school in the mid-50s, and I think I was a passably good student, but I'd never heard about any of this. And the reason is that in law school in the 50s, they didn't teach us about the rights of First Nations people. It wasn't on the curriculum. As far as the law schools were concerned, First Nations people didn't have any rights worth discussing. And, you know, I realized that. When I took on this case, I came to Nanaimo, I talked to the council and the elders. And because I had just opened my law office and didn't really have any clients, I had time to study this subject. And my office was in a little two-story building where the Four Seasons Hotel is today, just across the street from the courthouse, and I went over to the courthouse library and studied this subject, and I realized there was a subject in the law known as Aboriginal title, and it had been discussed at length by Chief Justice John Marshall of the Supreme Court of the United States in the 1820s and 1830s. It was discussed in an indirect way by the courts of Canada in the latter years of the 19th century, but then it had just fallen off the map. And so my task was to find this treaty if I could, and I went to the provincial archives in Victoria. And some of you have been there, I'm sure, and the provincial archivist was a man named Willard Ireland, an historian, and he was a big help. And he said, well, here are the treaties. Governor Douglas, between 1850 and 1854, signed 14 treaties with the First Nations people of Lower Vancouver Island. He started off in what is now Victoria and worked his way up the east coast to Nanaimo and Fort Rupert. And after that, the influence in the colony, the old colony of Vancouver Island and later the colony of British Columbia, the influence of the settlers who opposed any recognition of Aboriginal title or any existing right to the land held by the First Nations people, those folks, the settlers, their influence became predominant in the old colony of Vancouver Island and later the mainland colony and the United Colony of British Columbia and the province of British Columbia for many years. So no more treaties were made. Governor Douglas's hands were tied. You had some historians here today, and I may be treating the history of the time as a little malleable, but I'm doing my best. There was certainly, from the time we had an elected legislature, the legislature was unwilling, the settlers were unwilling to acknowledge that there was any obligation to make treaties with the Aboriginal people. So we had these 14 Douglas treaties that had never been enforced, had fallen into desuetude. Nobody knew about them, nobody was interested in them. But anyway, Mr. Ireland showed me these treaties, and one of them was up on the board here. I think Mr. Lutz had it up on the board, and that's how they looked. They were only about one page. The problem was that I was defending Clifford White and David Bobb from Nanaimo, and there was no treaty made at Nanaimo. There are treaties made everywhere else on the eastern shore of Vancouver Island as you move north, but not at Nanaimo. But there was a blank sheet of paper that was signed with 159 X's. This is a blank sheet of paper. And it was, these were 159 men of the Saliquan tribe. So, at that, and they had received 638 blankets, but it didn't say what for. It was otherwise a blank sheet of paper. And it didn't say where it was. It was December 23rd, 1854. So that was the treaty I had to go on. And you will, the lawyers here will know that I couldn't ask the elders to testify and say we have a treaty, our forebears tell us this, and so we are asking the court to recognize through our testimony this traditional belief in our community. It wasn't until the Delgamuukw case in 1997 that the Supreme Court said, yes, traditional oral history of Aboriginal peoples can be used in courts. We couldn't use it then. And so we had our blank sheet of paper. We had 159 Saliquan who had signed this. So then I went to see Wilson Duff, an anthropologist who worked in the Parliament buildings. He was known as provincial anthropologist. If there are any anthropologists here, I'll bet they didn't know we once had a provincial anthropologist. That was his title. And he was an outstanding man, along with Willard Ireland, they were two scholars who were eager to help and helped me greatly at the time. Anyway, Wilson Duff said, well, let's look at the census that Governor Douglas did. He did a census of Vancouver Island in 1850. And the census showed that at Nanaimo, there were 159 men in the 4 Nanaimo tribes. So we had 159 people signing that blank sheet of paper. We knew that in the census there were 159 men at Nanaimo. By the way, there were many women and children. There must have been 1,000 altogether at Nanaimo in that census in 1850. A remarkable number, and gives you some idea of the losses suffered in the latter years of the 19th century owing to disease, the losses suffered by First Nations in this province. And then Willard Ireland guided me to the dispatches that Governor Douglas had sent to the colonial secretary in London, because of course he was governor of Vancouver Island and he was reporting to London on his activities. And in 1850, he had sent a dispatch to the colonial secretary in London in which he said he had made 3 purchases from the Indian tribes in what is now the Greater Victoria area. And there was a clue there, and if I can just find it here, I'll read it because it's quite interesting. And this afternoon when I was here, I think Cole Harris said a word on behalf of Governor Douglas, and I would like to do so too, because he said in his, I'm sorry, this was to the Hudson's Bay Company, but as we argued, the Hudson's Bay Company was an instrument of imperial policy. We looked at a dispatch Douglas had sent on May 16, 1850, acknowledging his instructions. Douglas told Barclay, that's the man in London, that he had already made 3 purchases with Indian bands in and about Fort Victoria. He had arranged these purchases at a total cost to the Hudson's Bay Company's exchequer of £150, 3 shillings and 4pence. And you'll recall that in Nanaimo, it was 638 blankets, no reference to any cash. Then Douglas said, and this is in his dispatch to London, I informed the natives that they would not be disturbed in the possession of their village sites and enclosed fields, which are of small extent. Some folks this afternoon were suggesting that they were of considerable extent. And that they were at liberty to hunt over the unoccupied lands and to carry on their fisheries with the same freedom as when they were the sole occupants of the country. 13 of the conveyances, as they were called in the archives, do in fact faithfully reflect Douglas's promises regarding the rights of the Indians to continue to hunt and fish. So obviously, when he started out and he got people in the Victoria area around the fort to sign in blank, he then filled it in later on, as he says he was doing here. He concluded his dispatch, I attached the signatures of the native chiefs and others who subscribed the deed of purchase, that's what we call a treaty, who subscribed the deed of purchase to a blank piece on which will be copied the contract or deed of conveyance. As soon as we receive a proper form, send me the forms from London, for God's sake. That's what he's saying. Which I beg may be sent off by return of post. Well, you didn't just put it in the mail. It took about 2 months by sea to get to London, and then another 2 months coming the other way. So that allowed us to say to the court in due course, that's what he did at Nanaimo. And so you should read those promises into this blank piece of paper that we've presented you with. And it won't come as a surprise to most folks here, especially the lawyers, that all of this was vigorously contested by counsel for the Crown, who said, well, this isn't a treaty, it's a transfer of land, that's all it is, a conveyance, that's what Governor Douglas called it. It's not enforceable, it's not a treaty, we're all familiar with the various renditions of that line of argument by the Crown in the years since. Well, could I say that I remember we were entitled to what was called a trial de novo. This is a procedure by which you could go to the county court and retry the case all over again. We had county court judges all over the province. And we went before the county court here in Nanaimo to try the case. And I remember that day because we had the trial in the old courthouse, and there's an old courtroom at the front of the courthouse on the second floor, and up above it, when you're inside, you can see this gallery that overlooks the whole courtroom. And to my surprise, I think, that gallery was full of First Nations people, all of them following the proceedings with intense interest. And this is a sufficiently sentimental occasion that when I got off the float plane today, I walked over to the courthouse. Said, I'm going to make sure that courtroom is still here, so that if anybody wants to go. Anyway, I walked in and toddled up the stairs and discovered there was a trial going on, but the courtroom was still there, so I went up to the gallery up above. It's still there, but I couldn't get in. It was locked. Anyway, that was remarkable, and Guy Williams, who was the president of the Native Brotherhood in those days and a very well-known figure among the First Nations leadership in the province, he shook hands with me when it was all over and said, Tom, he said, I am so pleased. I never thought I would live to hear the argument advanced on behalf of our people regarding these treaties and the whole Indian land question. Well, the county court judge decided in our favor. Judge Swinski was his name, and a very good judgment he wrote. The Attorney General appealed to the B.C. Court of Appeal, and 5 judges heard the case there. And we won 3-2, and the majority held that this was a treaty and was enforceable today. And of course, if it's a treaty, the provincial statutes establishing these offenses cannot be applied to Indians. And we, in the Court of Appeal, the argument took about a week, and the judgments came down, and one of the judges, Mr. Justice Thomas Norris, who was at the time thought of as an old Tory, but I appeared before him often, and in fact, he was the judge on the first jury trial I ever had. He was a judge of the trial court then, and it was a tough case, and I lost it, and he sent a message to me and come into my chambers, and I went in, and he was a very gruff old gentleman, and he said, "I've had these impossible cases too." He said, "Why don't you come and have supper with me?" And when he went to the Court of Appeal, whenever I appeared there on behalf of a trade union or someone accused of an offense or in an Aboriginal cause, he was just about always on our side. So all I can say is he was some old Tory. Anyway, he wrote a judgment, what's called a concurring judgment. 2 of the judges said, this is obviously a treaty. They relied on the evidence of Wilson Duff and Willard Ireland, and may I just, maybe I should say that, and I should have mentioned that Willard Ireland and Wilson Duff both testified. And I think that was the first time an historian testified in a case on behalf of Aboriginal people in this province. And Wilson Duff testified, and I think that is the first time that an anthropologist testified on behalf of Aboriginal people in the province. And I've paid tribute in other circumstances to both of them, but let me just give you the flavor of Duff's evidence. And this may take me a moment to find, but it's, if you would just forgive me and hang on. Yes, this is evidence he gave here in Nanaimo in 1964 at the trial. He said he laid the groundwork, Duff laid the groundwork for my argument on behalf of Clifford White and David Bobb. And by the way, I was here about 6 or 7 years ago when we celebrated an anniversary of White and Bobb, and kind of losing track of these things, but maybe it was the 40th. And Doug White, Chief Doug White, who was then a student at UVic, came with some of the professors and students from the university, and of course the First Nations people were there, and Doug gave a paper about the legal impact of White and Bobb, and but I was very pleased that Clifford White and David Bobb were both there, because many years before, when I guess we were all still in our 20s, they were the 2 men accused, and I was their lawyer. And I remember as we were all celebrating, I turned to them and said, I hope you guys weren't out hunting today. Anyway, Wilson Duff, who later became a professor at U.B.C., and I'm sure you're familiar with his work, he testified before the court. In brief, there were 5 local bands or groups in this immediate area, that is Nanaimo. They were together known as the Nanaimo tribe. The name of one of these local groups was Salakan or Salaquil, or variations of that name. These tribes or groups were quite migratory in their habits. Each of them had a village on the Nanaimo River where they would fish for dog salmon in the fall. They had a winter village right here on Nanaimo Harbor. The other 4 groups had their winter villages on Departure Bay, quite close by. In the springtime, all of these groups would move out to Gabriola Island for various kinds of fish and clams and other food, and in midsummer they would all go over to the Fraser River for other kinds of salmon. That gives you some idea of the extent to which they used and occupied the land, which is the expression we use in affirming the notion of Aboriginal title. Now, the name Salaquin correctly applies just to one of these 5 groups. However, I am convinced that Governor Douglas used the name to apply to the Nanaimo tribe. And I asked the question, what use would the Indians have made of their tribal territories? Wilson Duff said, they used different kinds of territories and with different intensity. They would use the rivers, of course, for fish with great intensity, and the beaches with great intensity, and the mountains and forest with somewhat less intensity. Yet they would go at least that far back, not only to hunt the land mammal, deer, and also other land mammals, but to get bark and roots for basketry and matting and such things. These territories would be definitely used by them and would be recognized by other tribes as belonging to them. So he indicated there was a well-established idea of tribal territory, tribal ownership of the resources of the territory. And that passage, just standing by itself, is, I think, evidence of the suggestion made this afternoon when I was here that Governor Douglas may have been mistaken when he said their cultivated fields are of limited extent. Borrowing from a notion someone expressed earlier today, their cultivated fields in the broadest sense extended all over this area, where resources they cultivated and used. Anyway, I don't want this to pass without acknowledging the role Wilson Duff played. And when we went to the Court of Appeal, before the 5 judges of the Court of Appeal, the county court judge had said, yes, this is a treaty. And on the appeal, the Attorney General's counsel said, no, this is not a treaty. It's not a treaty. It's just a meaningless piece of paper. We can all safely ignore it because it's been ignored for 100 years. And I thought, now you would think this idea would have occurred to me earlier, but I thought, well, look, if this is a meaningless piece of paper, we've laid the foundation, based on Duff's evidence, to establish Aboriginal title. If this isn't a treaty, all right, suppose the Court of Appeal decides it isn't a treaty. We argued, then we have Aboriginal title and we have an Aboriginal right to hunt that we are here to enforce. You know, either way, you lose. And in the Court of Appeal, we advanced that argument, and as I say, 2 of the judges on our side, no, this is a treaty. 2 of them said, no, it's not a treaty. But Mr. Justice Norris said, this is a treaty, but he said, if it isn't a treaty, then White and Bob are entitled to rely on an Aboriginal right to hunt. And he went on at some considerable length on that very subject, and that really was the first time a judge, I think, in the 20th century had discussed at length the whole idea of Aboriginal title as a part of Canadian law, something recognized by Canadian law. And Justice Norris, his judgment, both on the subject of the treaty and on Aboriginal rights, has been referred to quite often since by the Supreme Court of Canada. Well, as Roshan said, that was the first shot in the bid by Aboriginal people in this province to reclaim their treaty rights and to affirm their Aboriginal title and their Aboriginal rights. And I'm glad you're here celebrating the case and discussing it and indicating the directions in which it can go from here. And I should add that because I should have added, and but we're all friends here, and you'll forgive these moments of forgetfulness. I almost forgot to tell you the Attorney General then appealed to the Supreme Court of Canada. And when we were there, counsel for the Attorney General was going on, this isn't a treaty, this is just a piece of paper, and it's, if anything, it's a conveyance, a transfer of land. And I remember Chief Justice Cartwright, who was the Chief Justice of Canada at the time, he read the passage that was on the board here today from these treaties, because there are 14 treaties, and I'll take another shot at finding one of these. This is the one in Saanich, South Saanich, and they read, "Know all men that we, the chiefs and people of the Saanich tribe, who have signed our names and made our marks to this deed on the 6th of February, 1852, do consent to surrender entirely and forever to James Douglas, the agent of the Hudson's Bay Company, the whole of the land situate and lying between Mount Douglas and Cowichan Head on the Canal de Harrow and extending thence to the line running south, Now, the Chief Justice of Canada said to counsel for the Attorney General, well, wait a minute. He said, you say this isn't a treaty. And he read this from one of the treaties, because, of course, it didn't appear in the Nanaimo Treaty, except by inference, that is, that Governor Douglas had made that promise. So we should read it as if it had appeared. In those 3 treaties on southern Vancouver Island, where he had treaties signed in blank, he actually had it filled in later. In Nanaimo, he didn't get around to it. Chief Justice Cartwright said, well, look at this. He said, know all men that we, the chiefs and people of the Saanich tribe, have signed our names, do consent to surrender entirely and forever to James Douglas all the land. He said, that sounds to me like a people surrendering their land. He said, that's a treaty in my book. And the court, some of the lawyers here are used to cases going to the Supreme Court of Canada and judgments that maybe 100 pages or more in length are written, and sometimes there are 2 judgments, sometimes 3 judgments, and our task is to figure out where do we go from here. I'm not complaining about that. They're entitled to ruminate on all these questions that arise. But this case was decided from the bench. And I was there with Doug Sanders. Some of you will remember Doug. He was my junior at the time, became a well-known academic authority on Aboriginal peoples. But I got up, and the Chief Justice said, "We do not need to hear from you, Mr. Berger." And he proceeded to give their judgment in 2 paragraphs. So that's a 1-page case, and there has never been another one like it. So that, I only mention this because when we were successful, Frank Calder, who was president of the Nisga'a Tribal Council, and the 4 Nisga'a chiefs came into that little law office of mine about a year after that and said, "We want to sue the province to establish our Aboriginal title." So the Aboriginal title was going to be the next great cause. And of course, it was a case that in which the court was divided. Other cases came along, Sparrow, Delgamuukw. It was apparent that the great judgment of Justice Emmett Hall in the Nisga'a case, which acknowledged Aboriginal title as part of Canadian law and argued that it had never been extinguished in BC, that became the law of the land and the basis for treaty making, comprehensive treaty making in this province. So I just want to say that having been present at the creation, so to speak, and don't get the impression that this whole idea of a treaty and Aboriginal title and Aboriginal rights was thought up by some smart lawyer. When I came over here in 1963 to meet with the council and the elders, they knew all about it. They hadn't forgotten it. And it was the belief of Aboriginal people all along that their rights were important, that their claim to the lands they had always used and occupied was one that ought to be acknowledged in Canadian law. That was the driving force behind all of these cases that followed. I am so pleased to be here and to see a number of old friends and to see the way in which work continues on elucidating and enlarging the rights emanating from the Douglas treaties. And I'm glad to have played a small part at the very outset, and just as glad to be here today to meet you all and to thank you very much.
Thank you. Thank you so much, Mr. Berger, for sharing those remembrances and reflections and it really illuminating the human side of this story. But what struck me, I mean, the legal story you told and its genesis as a creation story in this area of law, but what also struck me is it is a pivotal story in the history of where we are standing right now, of this area, of this region. And it's a shared story of Aboriginal people standing up and wealthy benefactors coming to assist, of Aboriginal peoples from all over the province, of young lawyers, and creating that shared history, that common story together. Yet, I think it probably remains true that in this region, that story is fundamentally unknown and remains unknown. even though it's a seminal moment in the unfoldment of the relationship between Indigenous and non-Indigenous peoples in this country. And those stories are up and down this island, and they're all across this country. And as we unearth them and share them and speak about them, it really brings to life the character and nature of the challenge that we're all here discussing over these few days. So thank you so much again. I know there's a presentation of gift to be made, but I've been informed, I believe it's going to happen during the dinner. So I invite everyone who's coming to the dinner to make their way down there, and Mr. Berger to join us, and we'll carry on there. Thank you.